So this session is around AI systems and what that looks like, especially in the frame and with a background of judicial systems. I am joined by three honorable justices, but let's jump right into it. So we've had several conversations in the course of the day. We are all aware that AI is rapidly transforming various sectors, including in the judicial system, as we've all seen. This covers everything from automating routine tasks to advanced data analytics. AI has the potential to enhance the efficiency, transparency, and fairness of judicial processes. However, its integration into judicial systems introduces and raises important questions around ethics, bias, access, accessibility, accountability, and what role human oversight has to play. But between Honorable Aisha and Zion, I'm curious to know, are there any levels of AI adoption or integration or implementation in the different courts that you serve, the various countries, anything that you've observed that might be of interest for the room that can also then lead to further conversations in terms of imagining what else could come up of it? Honorable Aisha, I'll let you go first.
The judiciary of Tanzania owe a duty to the citizens of Tanzania that we serve, and therefore in recognizing that technology can provide a better, quicker, and more cost-effective dispute resolution process to the citizen, the judiciary of Tanzania adopted the ALMA wave, which is a transcription and translation system. Well, the judiciary of Tanzania has incorporated AI in its transcription and translation system for administration and access to justice. And this is breaking down the language barrier in Tanzania and aims to improve court efficiency. The judiciary couldn't hire stenographers for all 35 judges serving in the Court of Appeal and 109 judges in the High Court, and about 2,000 magistrates, but realized we can use artificial intelligence. So this automatic transcription has significantly reduced the judges and magistrates' burden of work, as the judges and magistrate job is now to listen and make decisions and not to do transcription. To ensure the system performs its translation task efficiently, the system was fed with Kiswahili dialects of various communities from Tanzania mainland and Zanzibar. Also, the system was also trained on the Tanzanian English attribution. So to start with, the system is installed in 11 selected courts out of 169 courtrooms in Tanzania. And the system is capable of automatically transcribing court proceedings into either English or Kiswahili. The same content can be translated to either Kiswahili or English, and parties can access the recorded proceedings online on the same day for review. So that's the experience we have on adaptation of AI in Tanzania.
That's really interesting. Thank you for sharing that, especially because at the intersection of using technology, including AI for judicial systems, is access to justice. And it's amazing and incredible that the judiciary in Tanzania is able to incorporate that. One of the things that you said, I think that stood out for me, well, there's two things. The first is around just the language barrier, but then also like the transcription and capabilities that allow for both Kiswahili and English. I think that's very, very, very interesting to see. I also like that you said that it also takes away the focus from the judicial officer and allows them to actually implement and put themselves into the decision-making of the case and the facts that are before them. That's fantastic. Anyway, over to you, Honorable Zion.
In terms of Malawi, I think our AI issues in terms of incorporation or inclusion hasn't gone as far as Tanzania being like rolling out. But I know a number of judges are using it when they're using the court spaces, but they're using it like, for instance, Zoom, with the Zoom transcription that you get from Zoom, from the Zoom space itself. But you do realize that it's very focused on individual judges who are progressive to understand how much AI could help them in their court space, but also looking at their court space, the courts themselves. So it's mostly within the High Court, rarely within the magistracy. And that's when you look at our courts, that's where a lot of the work is. So the need for us to ensure that the AI incorporation is not only at that level, at the High Court or that upper bench level, but also moves down to the lower bench is quite critical and significant. But one of the things I also note that is the AI adoption in terms of African judiciaries, it's still fragmented, and fragmented because I think there has been no discussion on a continental level to get us to agree on what we can use. And sometimes you tend, because everybody is skeptical about, is it the decision-making concept of it, or is it the other aspects like the transcriptions, the ability to do the case management and all those things? Everybody is okay with case management, e-filing and all that. But once we start discussing the other areas of AI, you find that there's skepticism that comes through, because I mean, you already know that judges will always say, oh, we have to be independent and impartial. And we also have, even the ability to use AI to summarize some of the things to us, because you come into a court space, you've got 100 pages of work that needs to be summarized into a judgment that's like about 15 pages. And so people always find, oh, you're using AI to summarize, but that's not right. And I'm thinking, this is 100 pages of work that you've had to go through, and having the summarization, because ultimately at the end of the day, you still have that human oversight over it, but that summarization. So I've used AI for summarization. I use it for transcription in terms of the Zoom. So for me, as in terms of Malawi, we've yet to get to the level of adopting it fully, but we are working on our ICT policy. So hopefully some of us can advocate for it to come through.
Thank you for sharing that. I completely agree with you, and that will be a segue to our next conversation around the issues in terms of implementing and adopting AI beyond just the administrative tasks that we think of that are agreeable to everyone. But one of the things that you spoke about that stood out to me was around democratization of the technology, because ideally and typically it should be accessible for others, right? You speak about it in the context of the judicial system, where the higher courts have access to it, while the lower and more subordinate courts might not. Globally, it's a conversation happening, right? What about the global north versus the global majority, not the global south? I do not call developing economies global south, because as a matter of fact, we are the majority, right? So the phraseology I prefer to use is global majority. But that being said, there's also an access issue, right? And democratization of AI is most of our content and most of the solutions that we are seeing being rolled out from the north versus the majority, or rather the global minority versus the majority. So it's a conversation that we'll delve further into. At this juncture, I'll invite Honorable Sylvester Ablor to introduce himself. Welcome, thank you for joining us, Honorable Justice. And maybe just jumping into how you're seeing the adoption and use of AI in Ghana.
Right, thank you very much, and it's an honor to be here. For us in Ghana also, you find that AI technologies are more skewed towards the higher courts, and the lower courts, which are also in the majority, are more or less being piloted with some of the projects. Generally, there is no systemic approach as we have it. You may have individual judges who may be savvy with technology, adopting the use of some AI technologies to assist in summaries, in helping to evaluate some, or detecting whether some electronic evidence might be fake or whether it is genuine. All these assessments are not part of the system as it is. As a system, what we are gearing towards is now getting to the electronic phase, where the judicial service is trying to get everything electronically available in terms of e-filing, in terms of judgments, in terms of having access to the judgments from the courts. The project was nationally started. There was a funding that was made available, but it's been slow. So you find that in the capital cities, some of the lawyers are able to do the e-filing, But then in the remote areas, it is not available. So that kind of access is becoming a bit of a challenge. And then also you may find that even access to internet, now it is better. So that was the main backbone challenge, internet availability, and then having the service itself. Fortunately for us, during the legal vacation this year, some of the high courts are able to conduct court procedures online. And so, yes, there may be a judge in Accra, a witness in one region, a lawyer in another region, but then hearings are held online, and then all these are being piloted. So the idea of adopting AI tools, electronic systems to make the system more seamless and easily accessible is one that is in the majority accepted, but we are still slow in getting into a universal system within the country as a whole. So yes, we are getting there. It's slow, but the resilience of the system has not really caught on. So yes, it's a growing system for us as a nation.
In Tanzania, in relation to e-filing and e-case management system, we have gone entirely paperless. So the e-case management system allows litigants to file cases electronically in all levels of the courts. And also now judgments, orders, decrees, and ruling are signed electronically and can be accessed on the same day when they are delivered.
Amazing. I remember also one of the things you said was that at the end of the day, with the transcription of the different cases, that the litigators are able to log in and see all of their the updates of, you know, how the case proceeded, which I think is fantastic and is quite incredible in terms of advancing access to justice. I see a few questions and a few comments on the chat, but just before we get into that, let me ask a second question to the honorable justices. When you're writing judgments and when you're preparing them, at least I know we are all common law. There's two parts, right? If my law school training it suffices and serves me well. There's the ratio decidendi, which was the rationale and the legal parts of it. And then there was the obiter, you know. And I remember we used to read a lot of obiter because that was more persuasive. It was not fixed or cast in stone, but it was the opportunity for judicial officers to express themselves and share thought leadership. So I invite you to share some of your thoughts. The question I have is around what do you think and how perhaps can we implement use of artificial intelligence within the judicial systems well when it comes to things beyond what Honorable Zion said is non-negotiables. I mean, not really non-negotiables, but non-issues, right? So case administration, non-issue. Calendar updates, transcription, non-issue. What about things like sentencing guidelines? How do we determine who serves what sentence? Do we adopt and use AI for that? Things like discrimination, right? For example, in Kenya, is there a presumption that if an accused person is brought before a court in Makadara law courts, for example, which is in the eastern part of the city, but then is typically known for more criminal, more violent cases. So very hand kind of criminal cases. So assault, violence, robbery with violence, such cases versus Milimani law courts, which is more white collar, posher, nicer, or city courts, for example, which is where we have people arrested for petty crimes within the city of Nairobi that are taken to. How do we implement that and make it more meaningful and more helpful and as a tool to enable the ends of justice and access to justice versus, the more non-issue uses of it?
All right. So personally, I am amenable to accepting an AI tool for detecting the potential for recidivism and detecting certain characteristics within personalities. But the challenge here is that whatever system it is that ought to be created or to be used must be reliable in the sense that we have to reduce any form of prejudice in the algorithms as possible, so that where we may look at certain cultures well, in Africa, we don't really have problems with races, but cultures, tribes, certain communities have a certain idea of a certain character. But that prejudice must not operate against everybody. So if we are to employ such a system, we must make sure it is reliable. We must make sure that, look, whatever it is we are going to use it for does not operate a bias against a certain group of people. And if it is going to be used also, the judge who must use it must understand with sufficient explanation by the developers to know how to use it and understand how it will operate. If we are not able to come to a certain agreement with these indices, then it will be difficult to adopt a particular AI system. And here also, I'll say that there shouldn't be one that will say, if it applies in Ghana, should be applied in Kenya, because there's particular characters and behaviors may differ. And if they are going to be tailored towards a particular community, then it must look at all these indices to be able to make it one that will be more useful and beneficial, and that the negatives will not outweigh the positives when it comes to that. So that's how I would look at. Personally, I would wish that such systems are adopted, except that they must be tailored to meet particular judicial systems to satisfy the needs of the community. Yes.
So two things stand out for me. First,
Yeah.
the fact that you said, or you alluded to bias being biased in different
Exactly.
ecosystems and different spaces in Europe and global minority countries, it might be a race factor. In Africa, it might, other nuances. So that was interesting to hear. Thank you for sharing that. And then secondly, is just around how do we build those models, So for me, it sounded like the right data and building responsibly right from the word go. Honorable Aisha, Honorable Zion.
For me, the use of AI for sentencing guidelines is not problematic if we're using it for the purposes of having a predictive model on sentencing on various areas of the law, because you can feed it enough information that it could give you a predictions of this kind of sentence or this kind of issues. What I would agree with Justice Sylvester is the same ideology that says if it is for the predictive nature of the sentencing guidelines, the human oversight cannot be underplayed. It still must exist, because when you look at criminal cases, and I'm a former prosecutor, you see that the nuances of cases are there could be two similar incidences, same amount of money, same amount of force used, but age of the offender comes into play, whether it was done with others or done alone. All those particular issues would have to be fed into that system, but some of them need human oversight to actually remind the court itself that when you're sentencing, you're also dealing with the person in front of you. You're not dealing with what the general sentencing guidelines talk about, because every individual that comes into the court must get the justice that they need to get for the crime that they committed, as opposed to the generalized sentencing that comes into play. That's why usually you would have what is the minimum and what was the maximum for sentencing. And it is this space between the minimum and the maximum that is where each and every offender would have to fit into. So yes, the nuances need to be understood, the context need to be understood. And most importantly, we all know that even with us as human beings, the concept of stereotypes and bias is intrinsic in us. And we have to learn not to be biased. So yeah, the team that is developing the AI for the sentencing guidelines, you would also have to ensure that you understand what kind of biases, what kind of background they're coming from. So the diversity of that team that develops it also becomes a very critical issue for ensuring that we avoid the biases. And we also look at the concept that sentencing must be for the offender and for the offense and for the victim as well. So those particular parameters, the use of it is very important, but not underplaying the human oversight that needs to come with it. Thank you.
Just what you said about unconscious bias, the need, but also the ability to unlearn whatever biases we have, but also just being pragmatic and realizing that, yes, we do have stereotypes. I think the other thing you said that stood out to me was just around the need for oversight of the human being. which then I think is a great mitigating factor in the implementation, adoption, and use of AI. Having a human at the end of the technology to counter and cross-check and ask, what are the unique circumstances in this case, I think are very important to note. Rachel Magege, I'll let you ask your question now.
Thank you. Thank you so much. And good afternoon, good evening, everyone. I really love this discussion. And because a lot of the conversation was on the capacity of judges themselves, and I'm very pleased to see Judge Aisha Sinda. I know we've worked before, and Judge Zion Ntaba from Malawi. My question is, with the rest of the staff and officers who work in courts, so you have the clerks, you have the court officers, you have different other members who work in courts, how much capacity building is being done for them when it comes to artificial intelligence? And with artificial intelligence coming in, do we find that some will lose some of their jobs, or do we still maintain some of them when it comes to how AI works and how we can all understand it together? Because I know in Tanzania, our Chief Justice has made a lot of comments and many speeches on how to capacitate judges and even lawyers, but I think it's also important to look into the clerks and registries and other officers. So I just wanted to know what is being done in that context. Thank you so much.
Ghana as a country, generally when there's a general adoption of a system or a process, there is also the likelihood of training and building the capacity of the court staff to align with it. So you find that the policy may come initially as an idea. A few judges will be trained, and then you find that wherever or whichever court they are supposed to man to have that process working, the staff are also trained. Where the challenge comes in is when you have a situation of adopting it generally, then you find lapses in the capacity building of the staff because they are more in terms of the number. The time for training is longer. And then doing it nationwide is also, so even for purposes of training. Now, trainer for those persons to be trained, even if we decide that we are going to do it within all or distribute them for all the regions, it's going to be done in phases, in terms of time, in terms of cost. So it's slow. And it's also one of the reasons why adopting some of these digital systems generally has been slow for us. So yes, training is all part, it's more of a comprehensive systemic approach that is taken, but generally slow, yes.
I would say most times clerks and that are the most forgotten aspect of the training, because they come at the tail end and not at the beginning. Yet they handle a lot of our administrative work. So you find that we kind of we do prioritize. I think it's just this top-down approach that we continuously have with working with a lot of adoption of anything new within judiciaries, and I would say generally within government institutions. So you find that where the most training needs to go to, which is usually the court clerks and all other officers, it is the least amount of resources are put into there. While the biggest amount of resources are put into judges, the magistrates, and I mean, not even magistrates, I would say the magistrates will be court clerks, other officers, magistrates, and you have judges. But you will find that the most resources are put mostly within the judges' spaces, yet their limited use of the system, because we come in at the tail end when it's trial time, when a lot of the issues come into play before that. The filing, the ability to set up the courts, the courts themselves. Like for us, one of the interesting things we had to do was during COVID, we had to teach. I mean, as judges, in my region, I had to teach my court clerk and say, this is how you set up a Zoom. This is how you do a teleconference. This is how you do this, and I've had to continuously do that for every technology that I'm trying to use, and so you see the resources don't get put up for them a lot. So the capacity means judges themselves must take initiatives. If you're a judge in charge in a region, you must take the initiative to ensure that your team have the ability to understand. So having to tell your registrar that, look, You must have a session with our people about doing this. You must have a session on this. So for me, the innovation also comes with you as the person in charge of that space, because most times capacity building usually stops at the top and not necessarily at the bottom.
Honorable Aisha.
Thank you, June. I agree with my former colleague, Rachel, that one of the significant concerns surrounding the use of AI is the potential job displacement. On the good side, AI has the potential to automate certain tasks, traditional, which were performed by clerks. And now, like in Tanzania, what we are experiencing with the e-case management system, now judges do most of the jobs which were traditionally done by clerks. So the impact on judges is relatively limited. And when I gave my example earlier on the transcription and translation system that we are using now, the judiciary were supposed to hire stenographers, but it thought fit to use AI instead. And also I see most senior judges are facing a lot of challenges in adapting to AI technologies due to a lack of technical expertise. So I think now it's the right time also for law schools and educational institutions to offer specialized programs in AI, legal technology, and project management to equip future legal professions with the necessary skills.
Well said, and agreed. Quincy Otieno, I know you had a question. I don't know if you'd like to ask it live or should we read it out?
So I do appreciate the justices and what they are talking about in terms of ADR and the court system. I'm a big advocate for this, and I teach on ethics. So during the 40th anniversary of the Chartered Institute's meeting in Kenya, I had a chat with Jonathan Wood, and I was leading a discussion on AI and ADR, and I wanted to pose the same question to the panelists as to whether are we really ready as a judicial system, or the judicial side of the profession, are ready to embrace AI systems, which one can from the onset render decisions, meaning it starts from the process of initiation of the court of the case all the way to giving your judgment. Two, or what would be the uptake or the reception of using AI systems just to render decisions or summarize court text or documents? Yes, that's my question to the panelists.
For me, I go back to the very nature of saying, look, when it comes to when you look at ADR, you're looking at whether it's arbitration or mediation. When it comes to arbitration, you are looking for a person. One side is looking for a decision of winning, whilst with mediation, we're looking for a win-win situation. So when it comes to that, I think for the win-win situation, the human nuance cannot be left out, because you are negotiating between two parties. And so having AI give you the reasoned outputs, the possibility, the possible options is something that should be able to be done, and will become very useful, because sometimes you would have not looked at all the parameters. And with AI, if you input the information, it will look at everything. Same thing with arbitration. I would stop with rendering the decision, because ultimately, I think at the end of the day, you still want that arbitration decision to be able to be been backed by a human element out of it. Well, same thing with the mediation, because ultimately, at the end of the recent outputs could be given, they'll be taken on board by you and say, look, this sounds feasible, this sounds feasible, this sounds feasible, and you give it to the parties, and the parties would then say, I think we're more amenable to A rather than B or C, because it is a mediated agreement. While with arbitration, it's your decision ultimately at the end of the day. And the thing is, there still has to be some accountability, because ultimately the arbitrator has to be accountable for that decision. And AI, you cannot go and say the AI is the one that made the decision, when you as an arbitrator is held accountable ethically for that particular position, for having taken on that particular case. And I think that's one thing a lot of judicial officers would struggle with on the decision-making aspect, to say, look, the accountability of this work still requires that you as Justice Ntaba must make a decision, and you will be the one that when it goes on appeal, you will be checked. Were you impartial? Were you independent? Were there any other elements out of your decision making process, or even the decision itself that were influenced? So I think that's one thing that we need to always remember with the concept of AI. Its use in the whole process versus the final ultimate issue, which is decision making. So for me, I think those are the nuances that I keep grappling with every time I have to consider the use of AI. Yeah, in whether it's in a mediation or arbitration, or even in just a case itself.
From my end, I'll look at it from this position where we all have to understand and accept that the AI system is only a tool that is to guide the judge or the mediator or the arbitrator make a decision. So here I am now segueing into where Justice Ntaba ended to add to the point that final responsibility lies with you. You may use it as a guide in terms of identifying what indices to use based on the information or data you are getting from the parties. If I use it as a system to guide me, I input the key information in there. Okay, what am I supposed to look at? The final decision now comes to me, because you may be presented with a situation that has a uniqueness that may not be taken care of by the AI system. So if that does not capture that uniqueness, I am still expected to make a decision. AI system might not give me the best of decisions in that instance. I have to make a decision based on my unique knowledge, my unique experience, to be able to fashion out something that is more useful and more purposeful for the parties, whether it is one that will guide this person or that person, or it's one that uniquely satisfies their needs. We always have to understand that, look, this is only a tool that we need to use for our work. At the end of the day, judging is the work of human beings. We cannot leave that to the system. Yes. So yes, adopting it as part of the ADR system, yes, by all means, we should be able to do that, because in the heat of the moment or in that time when I'm supposed to make the decision, I may need a certain guidance. I may need to refer to certain indices that may come from the tool that is uniquely tailored for that purpose. Thank you.
I do not go far from my colleagues. AI just plays a supporting role in mediation, arbitration, and the overall adjudication process. And it offers new possibilities for resolving disputes more efficiently and effectively. And it can assist in the negotiation process by predicting the outcome. And at the end of the day, the mediator, arbitrator, or a judge can focus more on the human aspects of the law, on empathy, advocacy, and the pursuit of justice.
June, Quincy seems to have a follow-up question.
A follow-up question. Justice Ntaba said that there's need for, lack of a better word, human on the loop or human intervention because they're professionals. So my follow-up questions to rather the whole panelist would be, do you think as the legal fraternity, it is about time we put up rules for professionals, meaning lawyers and judges, for the use and disclosure of AI in drafting, in rendering decisions, and using it as a tool?
Any use of imaging tools, like right now, we talk about using Teams, Google, all these things. Google Meet, Zoom, all these things have yet to be put into our policies to have what are the ethical boundaries around them. You've seen people who use, there's so many things that that the emerging technologies have yet to come into our policies and our guidelines, especially for us as in the legal space. Other areas have actually moved further than us. I think we've been very reluctant to actually say we're using these emerging technologies, except for the ones that are actually used by everybody else, the Zoom and all that. But a number of us lawyers and judges will feel very threatened to say, look, you put as a note underneath your judgment that said, I used AI to summarize the parties' parties' documentation or submissions, you know for a fact that a lot of people are going to be reluctant to do so. But it is necessary that we do that, because it then highlights to everybody else that there's certain fundamentals of this judgment that were not done by a human being, but were done by a system. And it needs to be known which part of that judgment was not done by a human being. Was it the summarization? Was it the aggregation of the issues? All those particular parameters are very important, because then when it comes to appeal, review, and confirmation, it becomes necessary to check back, because we have a system as within the justice system that says everything that we do is reviewable by the next court, So all parameters of your judgment, your submissions, must be known to the people. So if we're talking about transparency and accountability, that is exactly that. If you're going to use AI, there must be some level of transparency and accountability, even for us as the people using it, to the public that we serve. So for me, yes, I believe strongly that there needs to be guidelines, if not a policy direction within that space. Thank you.
Justice Ntaba, you're a much better human being than I am, which is probably why you're on the bench and I'm not. Justice Sylvester, over to you.
Yes, I was going to add just a bit to what she has said. I found out from some of the systems that have adopted AI in their judicial system that as part of their ethical rules, whether lawyer, litigant, or judge that uses an AI system must one indicate or disclose the AI system what amount of work or contribution the AI system made. And this is mainly for purposes of verification, because as they say, we can trust AI, but we must always have the responsibility of verifying what AI is churning out. So if I am using it and I'm not disclosing, there are issues that may come up. How am I going to own up to it? So those people have come up with, and I think it's a very good policy they have adopted. We may learn from it if we decide to go that path. As it is now, we haven't made a decision. Those who are honest about it are saying, I use it. Some are not that honest, but if we make it a policy, disclose if you used it, disclose how much of it you use, so that anybody can verify as much as you would want to. So that's just the bit I wanted to add to it. Thank you.
I was just thinking about it, and I don't know if there's a phrasing such as AI shame, right? Because I guess the perception that we have around use of AI has been quite negative, right? Generally. And part of that might be because of the negative impacts that we've seen, right? Or the negative effects. Obviously, it hasn't been at a high level that is like with the justice system, but then with things like, using AI for marketing and advertising, then you see this picture of someone with 6 fingers, or in writing, which is where I think there has been a lot of AI shame around, especially. But it's interesting because what I hear you to say is, yes, you may use it, but then let's also have rules, right? And someone said self-regulation. Let's set boundaries that say this is too far. But also the place for transparency, because we like to say like the solution to information is more information. So just being open and saying this portion of this judgment, yes, I used AI to summarize the facts, to review the sentencing guidelines, to review past decisions, but the final decision was by a human and I take full responsibility for that. I think that sets the boundaries. Anyway, so we have a few more minutes left. I'll touch on some of the questions. One was around what are some of the challenges experienced in the judiciary presently, and where do you think AI can come in to solve those challenges and how that can be done? I think that has been answered in bits around, administration, case administration, case management, summarizing the facts, supporting sentencing and sentencing guidelines. I don't know if there's anything else any of the panelists would like to add.
For me, one of the biggest things that AI could do is actually the ability to have remote legal. When I saw e-Sharia, is it e-Sharia? I found that very useful because, I work in a system whereby 3/4 of the people that come even before my court are unrepresented. And I'm taking a lot of time having to explain to them what the court process is, what they need to do, how they need to answer, and all those things. For 45-minute session, for 45-minute chamber application, it takes an hour and a half, because I have to make sure that they get to understand, they're able to do that. So having AI before they come to court to explain certain things, to simplify the situations for them, including even legal jargon, because they could fit it in whatever summons that they were sent and ask questions from that. I think that is very important. But also the ability that AI itself can reach them remotely. They don't need to come. 3/4 of our courts are centralized. We continue to be Africa continues to be very centralized in terms of its court systems. So the fact that it's centralized, the need for AI tools to actually ensure that we reach the hardest to reach. Lastly, we are a court system that is we've yet to become very disability friendly, or not even friendly. Friendly is not the word for it. Disability responsive. So AI actually takes that big step of actually bridging that gap. A lot of people are able to speak within court spaces. They're able to relate things that we usually would not have, because we don't have sign interpreters. We don't have machines that could translate, even if in our court spaces. So I think AI has its major use, apart from the back end, which is our work. But even from the front end aspect, it will still also be able to be very useful and important especially for marginalized communities or people that are vulnerable within the system. Thanks.
Edie, there was a hand up. Edie, I don't know if you want to ask a question.
Thank you. Yes, I just wanted to have to add something from what Aisha has addressed, which is very crucial. It's seniors now to supervise juniors in terms of the use of AI and all that. Now, my question is, how ready are the seniors as well? Be open-minded also to be to welcome those changes from juniors, because I'm saying this because it's a development which have been due to their time as juniors, and some of them might be new to most of the seniors in the industry. So how ready are they now to be open now to late the junior and to be taught something new? How ready are they? I mean, I think it has to be reciprocal in a way that for example, I might say someone who is Gen Z, some of the technologies, AI and all that, might be introducing during their time. So they might be more confident in that area. I think now it has to be reciprocal for these seniors as well to welcome and to be open-minded for these juniors and be able to learn from them. So what do you think of that? Is it possible? And if it's possible, do you think we might have more seniors open-minded for that?
For me, I've never had issues with juniors giving feedback, even on judgments. I think this concept or ideology we have within Africa, that seniority means wisdom, or seniority means the ability to know all, is what I find very problematic every time I sit in this space. And I say that with all due respect to everybody who's senior above me, because I believe in the concept of, if you truly are going to give everyone the best of yourself, it requires the ability for you to learn from all angles, whether from top or whether from the bottom. As I said, I'm a former prosecutor. My first charge sheet was reviewed by a paralegal or a law clerk. He taught me how to draft the charge sheets when I went into the Ministry of Justice at the DPP's office. And he was the first person I went to with court, because he had more court experience than I had. And I'm forever thankful for him because of that. He taught me how to be a good prosecutor. And he didn't have a law degree. He had a diploma in law. So coming from that space, I do not see why I cannot be taught by a Gen Z. I mean, my nieces and nephews are always constantly telling me something new. They know more things than I do, and I'm learning from them. So when it comes to AI, I leave it to them to teach me what is good, what is bad, and all those particular parameters. So I have no problems. I'm just hoping that my fellow judges don't have the same problem as well. Yeah.
I'm excited to hear your response, because I fall in the same situation where I don't mind giving my drafts to clerks, registrars to read over. I don't mind sharing whatever research I have done for confirmation from, because one thing I tell some of the staff is that I am a senior only means that I got there before you. It doesn't mean I got all the information before you. And there's so much available, especially with the tools that the younger generation are using, that we have no idea of. And technologically, I think we are, comparatively, we are inept, and we really have to accept the fact that they are way ahead of us. And the humility to understand that all I have over you is time should make us also recognize that based on the experience we have, there's always a lot to learn, and there are new things coming up. There's just so much going on out there that we don't as yet. So we all need to accept that humility, that apart from my responsibility, I need everybody's input whenever the need arises. Yes.
I see someone from Zambia. I don't know if they wanted to say anything, but I see Polly's hand, and I think that's the last question we'll take in the interest of time. So Polly?
Given that we are embracing some aspects of AI tools in our administrative aspect, because so far I think the administrative aspect has taken a greater center stage than the decisional aspect, the substantive aspect of judicial positions. So my question comes to the point where we have litigants embracing AI tools. Recently, we have advocates. I don't know if it's so unethical, but advocates have been developing their own avatars. And we who attend courts virtually, Justice Sylvester or Honorable Sylvester is leading or is sitting in court, but we have Polly's avatar. Probably the tool is so developed in such a manner that it's able to speak, especially on mentions. We are ready to proceed, we are not ready to proceed. So my question is, where do we put that in terms of ethics, especially legal ethics? And when AI tools are being adopted, now we have got avatars attending courts. And at the same time, we've got justice system also adopting AI tools, for example, in decision makings. How do we actually balance the two, especially when it comes to ethics and also the laws that require the advocates to appear before court and the regulations that follow them?
You've hit the nail right on the head. One of the most fearful things that users of AI or adopting it to the judicial system have been worried about: abuse of fakes and deep fakes to outwit the justice system. Do I have an answer? I don't. The only thing I can say is that, look, it is only an AI tool that we can use to identify some of these situations, because organically, we cannot readily look at it and say that, look, this is a fake, this is an avatar. It's only an AI tool that can be used to fight that kind of degenerate systems that may be coming up. So much as we are advocating adoption of AI, identifying possible challenges in the future, one of such being this, also helps us to plan towards dealing with some of them before they come up. There are others that we may not be able to identify as yet, but once we are able to anticipate and prevent them using the necessarily required tools, then we know we are onto something. This is subject to discussion, but we must acknowledge that it's a possible risk that is attendant to, yes, the use of AI.
I would like to respond to that. I think the key issue here will be on liability in relation to AI. Because as AI systems become more advanced, it can be difficult to determine who is responsible for decisions made by the AI. So as we earlier said, I think now laws and regulations will be needed to clarify liability and ensure that individuals and organizations are held accountable for the actions of AI systems.
Justice Ntaba, you'd like to add, but I'll also invite you to make closing statements and so that we can wrap up the session.
I think one of the things that we need to always underscore is the concept of the risk. I think risk mitigation and risk identification becomes very critical for any system that is adopting anything new. And with risk identification and risk mitigation, we also have to understand that both those users behind, in front, will still have people that are unscrupulous, people who do not want to keep up to with their moral ethics. But also, I mean, seriously, as lawyers, if you're talking about legal representation, how is that legal representation within the court, within the law, and all those particular parameters? So I think the issue is to have, as Justice Aisha said, have the laws in place, have the policies in place, review our code of ethics for lawyers, review the code of ethics for judges, review the code of ethics for judicial officers, judicial staff, so that when AI comes into play and it's fully integrated and incorporated into the system, there is an ability for the transparency to come through, the accountability, which is very critical, because as judiciaries across Africa, we keep having every year having problems with our accountability, whether it's through corruption, through all delayed judgments, backlogs, and all those things. So the accountability aspect of it, I think, becomes critical for us to ensure that if we do adopt AI, it actually does what it needs to do, which is promote the rule of law, protect people who need to be protected, but more so just ensure that the service delivery is there, because ultimately that's what we are there for as judiciaries, to deliver service to the people that we serve. Thank you.
Well said, thank you. Any closing remarks?
My closing remarks, we need AI. AI is here to stay. It's going to be part of our entire life and as part of the judicial system. Ours is to regulate it and use it for the best of our communities. Thank you.
All right, so thank you so much to everyone for joining this session. It's been very insightful, very interactive, very engaging. The chat has been buzzing left, right, and center. So thank you for all sharing your experiences. Thank you for the questions as well. They are very engaging. To our panelists, honorable justices, thank you so much. You have enriched this conversation and made it so thrilling, you know, even if we were to send you prep questions, and I did not send them prep questions. So these are your judicial officers delivering and working overtime impeccably well. I think the three things that stood out for me from this session is, number one, building inclusively, right? That's where this tool comes from, and that will mitigate all the issues we have around ethics, bias, discrimination. Secondly, capacity development, right? But at all levels, beyond just our judicial officers at the top, let's also consider everyone else in the value chain of the access to delivery and delivery of justice, or the access to justice. And the last one that I think every single person has said we all agree on is AI is a tool. It's a supporting role, right? It's something that aids and assists the delivery of justice. The final decision should and must lay with a human being, which is what the basis and the foundation of the judicial system is. Thank you so much, everyone. This has been fantastic. Have a great rest of the day, afternoon, evening. Asanteni sana.